This is Outnumbered. I'm Andrea Tanteros, and here today, Sandra Smith, Harris Faulkner, Jedediah Bila, and today's hashtag one lucky guy in his suspenders, Bob Beckel, and he is officially outnumbered, a position that you're used to being in, right?
It doesn't change. Yeah. I mean, it's 4-1 here and 4-1 at 5 o'clock and 3-1 at Hannity.
But you like 4 women to 1 man. Those are odds that Bob Beckel can embrace.
I like it not in a political sense. I like it in a social sense.
Well, you don't know how this is going to go. This could be the most fun you've ever had.
This is very
I
social.
enjoy the show very much, except for the set.
Well, and you're going to enjoy it.
Here we go. You live alone in a bachelor pad.
Yeah,
you should
it's really
love
nice.
anything decorated.
Exactly.
Well, it's decorated. It's decorated well. I mean, you'd have to see it.
Well, the sofa isn't black like all the furniture in your bachelor pad, huh?
No, my sofa's black, yeah.
You have a black leather couch?
Yes, I do.
You are that guy, aren't you?
Yeah,
Okay.
I have a black leather couch. I have lots of mirrors in my bedroom.
Oh,
Okay,
man.
we have to move on.
Okay, let's go.
Let's.
Coincidence. We've got to not go there. A landmark decision from the Supreme Court yesterday. The justices ruling that closely held corporations can hold religious objections that allow them to opt out of the Obamacare requirement that they cover contraceptions for females. Now, this is the first time the High Court has ruled that profit-making businesses can hold religious views under federal law. The 5-4 opinion is a victory for Hobby Lobby. The company's owners, a family of evangelical Christians who sued, saying that the rule infringed on their religious beliefs and that the fine that they'd face for noncompliance would have been a massive burden. Shannon Bream is live outside of the Supreme Court. So, Shannon, tell us what this decision means.
Well, Andrea, for these companies, these closely held family-owned corporations, it is a huge win. You think about Hobby Lobby's got more than 14,000 or so employees. For them, a big win. They've always said that it's important to them to have high-quality health care for their employees. They didn't want to be forced with this choice, like if they lost here, that they would have to drop their insurance program and force these employees onto the exchanges. They didn't want to do that, but when I asked them, months ago, if you lose, what are you going to do? They said, listen, we're not even going to discuss that at this point. We're just going to have faith and move forward on this, and today a big win for them. The Religious Freedom Restoration Act was the law at the heart of this entire case. It was passed with big bipartisan majorities back in the 90s and essentially said, somebody shouldn't have to give up their religious convictions because they go into business. They shouldn't have to just practice on their Sabbath, whether that's Saturday or Sunday or another day. They should be able to live their faith 7 days a week, and that means making business decisions. Hobby Lobby's made no secret of that. I mean, they're closed on Sundays so people can have a day of rest, and if they want to spend that worshiping or going to church. And also they play Christian music. They donate millions to Christian causes. They make no secret about what kind of company they are. And they've said that, essentially there were 4 of the 20 mandated contraception methods they couldn't go along with because in their belief, those cause abortions or can trigger an abortion. So there's no way that they could be a party to facilitating or underwriting that in any way. And today, Justice Alito, writing for the majority, said basically the plain terms of the law make it clear Congress didn't want to discriminate in any way against men and women who wish to run their businesses as for-profit corporations in the manner required by their religious beliefs. So the law protected them. The dissent obviously not happy about that. And Justice Ruth Bader Ginsburg wrote for the minority the dissenting opinion here. And she also read her dissenting opinion from the bench, which doesn't happen a lot, but it does when people are very passionate about making their point. And her estimation was, listen, we make this balancing test under this Religious Freedom Restoration Act, but what about the thousands of female employees who work for Hobby Lobby? And her estimation, the majority doesn't care about them. Andrea?
Shannon, it seems to me, and you cover the court very closely, so you've seen the trends that have happened over the last couple of weeks and months. The court seems to be limiting the executive power in these series of decisions. And that's exactly what they did today when you read Justice Kennedy's concurring opinion, saying that he didn't agree with the other justices, or he agreed with them, but he disagreed for other reasons. His issue was that HHS put this mandate into place. Do you see it as Obama's executive power that he's been flexing lately being struck down?
It's possible. I mean, obviously, we had that unanimous opinion last week striking down his effort to make recess appointments to the National Labor Relations Board. At a time, the Senate said, hey, we're in session. And the opinion, which was written by Justice Breyer, not a conservative, and signed onto by all 9 justices, said, of course, if the Senate says it's in session, it's in session. You don't get to decide as the executive, they're not in session, I'm going to recess appoint people anyway. With this case, this is something that stems from the health care law, but it was written by an agency. It was written by the Health and Human Services Agency. It came through then Secretary Secretary Sebelius, of course. And that was something that Kennedy brought up during the oral arguments. He said, I'm concerned that this rule doesn't come from Congress. It's not an elected official who had any part in drafting this or voting for it. It's coming from an executive agency. It's not even a branch. A lot of people think it's turned into a fourth branch. We only have 3 in the Constitution. But Kennedy seemed to have a problem with that essentially the executive is communicating its will or enforcing its will through an executive agency.
Shannon, it's Harris here. Kennedy had a problem with what some lawmakers are saying they did too. I'm just looking at a tweet from Governor Bobby Jindal who says Barack Obama is now Googling, quote, can an executive override the Supreme Court? Hashtag Hobby Lobby. I was curious to know about the other cases that are pending like this one, Shannon. And I know that there are some because we're already hearing from attorneys who say, well, you know what? This means victory for my case and the client that I represent. Can you tell us a little bit about what's out there and what could be coming down the pike?
Yeah, we actually have another set of challenges to the HHS contraceptive mandate. These are coming from religious groups. And in fact, there are some emergency petitions pending right now that were filed late Friday night because a new deadline kicks in for them tomorrow. We're talking about Catholic schools and hospitals, groups that are not like Hobby Lobby. They're not a for-profit so-called secular company which does crafts and arts and that kind of thing. These are religious organizations who say that their entire function is as religious activity. Those are pending here now because they say the administration will say to them and has said to them in court, we've provided you an accommodation. You sign this form that says, I don't want to provide contraceptives to my employees, and then the insurer takes care of it. Well, these religious organizations say that's like signing a permission slip for something I don't approve of, and I don't think I should even have to sign the permission slip. So that's the next round that is pending here at the court. We do have those 2 emergency petitions. I would expect to hear on those today. But as far as other sweeping challenges to the executive branch, I think that those are going to be limited. That's not something that, from this opinion, people will certainly use this to argue their point,
sure,
but it's pretty narrow.
Shannon, is there any concern now that some of these closely held businesses, closely held corporations, will now see this as a means to challenging other regulations that they're not comfortable with? I know that was the big concern. Had this been a broader ruling from the Supreme Court and affected more bigger, more publicly held corporations.
Yeah, it's something the government argued about in the case, and it's something that opponents of this have already voiced to me today, and they've voiced all along. They're very worried that one of these closely held groups will be able to step up and say, well, I want to challenge Social Security or minimum wage or paying for vaccinations or something else. The court pretty much has said that's a slippery slope. We're not deciding that today. We're not condoning that today. We're just saying in this case alone, these religious freedoms are violated, and so the executive branch via this agency, HHS, can't force it. So they say it's narrowly tailored. In the dissent, Justice Ginsburg says, no, it's a sweeping decision. So we'll see whose prediction is right.
All right, Shannon Bream, live at the Supreme Court. Shannon, thanks so much.
Good to see you.
Okay, Jedediah, I think this is a wonderful ruling. And there have been some really terrific things happening at the Supreme Court lately. Yeah. This decision, though it's narrowly tailored, 5-4, still is a win for the First Amendment at a time when the administration and progressives are trying to trample on the First Amendment.
I agree. I also do think the issue of the slippery slope is interesting, though, because she's saying, well, this isn't coming up now. But are these new instances going to keep popping up? If, for example, somebody works for a corporation and they don't want to provide coverage for vaccines, if they don't want to provide coverage for blood transfusions, if they decide that they don't want to provide benefits to a couple that happens to be gay because it goes against their religious beliefs, I'm wondering if these are going to be filtering in one by one now, and the Supreme Court is going to have to evaluate all of these different things on a one-by-one basis. That makes us sort of look at everything and this issue of religious freedom in its entirety a little bit differently.
Now, Bob, you've said many times that Obamacare is the law of the land. It's not changing. We've seen this administration, though, give carve-outs for other different reasons. It didn't give a carve-out this time around, but it lost at the Supreme Court. How do you feel?
Well, first of all, let me just say that I disagree. I think it's exactly the opposite. It steps all over the First Amendment, number one. Number two, the idea that a couple of religious people who run a corporation for profit are allowed to bring their religious views in for 13,000 employees is absurd and obscene. And the third thing I would say, with all due respect to our Supreme Court reporter, every bill has regulations. Every bill that passes the Congress leaves it up to the executives to bring regulations around it. Not one gun bill is all and sweeping on every regulatory part of it. So that doesn't make any sense. But the idea that these people, what if they were Christian Scientists? What if they didn't? What if you couldn't bleed?
How do you argue that this bill tramples on people's, or this ruling tramples on people's
Church and
First
state
Amendment?
and the right. Listen, the people, those 13,000 have the right to free speech, and those people, 13,000, have a right to expect
Free
that
speech,
if the
no
law
one's saying that they're not allowed to speak their minds. They're just saying that this imposes on the religious freedoms of business owners.
It's imposed by two evangelical Christians who are imposing their views on 13,000 people, and they should keep in church.
But Bob, I think a few people might resent you saying that they chose to bring in their religious beliefs when they built this company on their evangelical and Christian beliefs 44 years ago out of a garage in Oklahoma.
So what?
It's not like one day they decided to impose religious beliefs on their firm.
So what? They built it. The Wright brothers built their planes. I mean, the idea that they built this thing and they built it, they didn't build it out of religion. They didn't build it a church. They didn't decide from the very beginning they were going to have some sort of religious.
No, but they built in Sundays off, and they built in a giving
lot of companies have
program for
business Sundays off. A lot of them.
The implication then is that government has the right to come in and tell that person, no, you're not allowed to build your business based on this value system. You're not allowed to have that because we say that you can't do that. Is that the right of the government,
Separation
or is that
of church and state says they've got absolutely no right to
Bob, the
impose
justices,
well, that's the Supreme.
Today they have a freedom of conscience,
which is fairly much of a joke.
You shouldn't have a conscience as a business owner to be able to run your business the way that you want. They're providing them with a number of different types of birth control.
Can I go back to if you were Christian Science owners of these things, you couldn't take your kid in to get care because Christian Scientists don't believe in getting care for kids?
Well, guess what? I have the freedom to go work somewhere else if I don't like it, Bob.
You know what I find interesting is I'm listening to you. I know Senator Harry Reid said something maybe echoing what you're saying today in a tweet, and in other places he's saying it now. If Democrats took such exception to what's going on, why are we not hearing more from them before this ruling, right? And the president has exercised 40 times. I brain room checked it just today because we know that it can change by the hour. How many executive motions, changes, and delays that this White House has made to Obamacare, the Affordable Care Act. So if they really saw a problem coming down the pike with any sort of ruling that might come from the Supreme Court, why weren't they more vocal? And they had an opportunity before this ruling to make some sort of a delay in the mandate. We've seen them do it before, or some sort of change. Maybe they'll do it now because now we, the taxpayers, will have to pay when someone opts for one of these four contraceptives.
Is that where we're headed? Because that's what Justice
Kennedy said. It took 2 decades to separate, to finally settle down on Medicare. This is a sweeping bill, Obamacare. It's going to have a lot of challenges. There's a lot more left to go before the court. In this case, this is the most egregious of all. Two people, and I happen to be a Christian and a very strong one. The idea that I would impose my values on 13,000 people is obscene, absurd, and unconstitutional, and the court should be bludgeoned for it.
Ironic, women fought this today.
Yeah, we don't have time to get to it, but they're saying this is a huge win for women at a time when Ruth Ginsburg...
Why is it a win for women? What about women who want to have a...
Women, female business owners.
Oh, I see. And not the 13,000 women who may want to have contraceptive help?
They do have contraceptive help. They only have 4 different kinds that they can't get.
Oh, they can pick and choose because they happen to own the corporation?
And you know what? Sandra Fluck, your buddy, she tweeted out earlier, this is not my boss's business.
It isn't.
That's what the court ruled today. Guess what, Bob? It said it's not the boss's business what these women do, what kind of contraception they use. It was a huge... She doesn't even understand what the Supreme Court ruled.
It's consistent with the ruling, actually.
Yes, exactly.
It is consistent. But it'll be interesting. We'll continue to see this broken down throughout the day and days to come because, Bob, I think you're right. I think that there are going to be a lot of people who'll try to challenge whatever it is. I'm curious to see what the White House will say now because this is a huge punch at the president's signature health care.
I'd be curious to see what happened if there was a Jewish group, if there was a Jewish couple that started a company, 13,000 people, but they were very strong Orthodox Jews, and they wouldn't allow their employees to use electricity or drive on a Saturday.
Yeah. Well, the problem is, Harris, though, that the administration has to keep acknowledging that the
what difference is that? That's their religious views.
All right, the IRS scandal getting lawmakers very heated. So is Lois Lerner's attorney lying for her to cover up those missing emails? Or was it really just a computer error? And the mom-to-be who ran an 800-meter race? Well, 8 months pregnant, you've got to see this. She has fans cheering. But should anyone be worried about her? We'll debate it coming up.